Hello, I'm Porschia Parker Griffin, and I want to welcome you to the Career 101 podcast, a place for ambitious professionals and seasoned executives who want an edge in their career. We're talking about all of the things you were never taught or told when it comes to career growth, development, and change. Now, let's get into it. Today, we are talking about non-compete agreements with Eric Sarver. Eric Sarver is a Manhattan-based employment law and business attorney who counsels, defends, and represents small to mid-sized businesses in various industries. A Long Island native who went to SUNY, Binghamton, and Hofstra Law School, Eric is the founding attorney of Sarver Law Firm. Eric and his associates help small to mid-sized companies seeking to navigate the ever-changing world of federal, state, and municipal law, labor, and employment law, while defending employers in federal and state courts, arbitration, or in government investigations. Hi, Eric. How are you today?
Hello, Portia. I'm doing fine, thank you. Really, things are going smoothly. It's been a good week so far, knock wood. So I'll take it.
Yes, that is great. Well, Eric, we are thrilled to have you with us to discuss non-compete agreements. But first, we want to know a little more about you. So tell me about 7-year-old Eric.
Yeah. Sure thing, Portia. I'm happy to start with a little background about me and who I am. Well, let's see, 7-year-old Eric. He was smaller than I am now, shorter than I am currently. I'm joking, of course, right? But that is true. I'd say, right, 7-year-old Eric was a very energetic, social, and creative, kid, young boy, right? Who just, loved learning new things, exploring, finding out different, just, aspects of life. I think 7-year-old Eric also was always sort of a champion of the underdog. I remember like being in second grade, I guess, and sort of protesting an unfair policy at recess where the lunch aides, if somebody was, quote unquote, out of line, they'd have to rate the whole class would have to be penalized. That was unfair, and I would, protest that to the teacher and principal. I think also I love to play. I had a great imagination. I was fascinated with time travel. I remember that. And so like everything was an opportunity to pretend I was back in the Middle Ages or, prehistoric times. Yeah, just went to school. Some of my friends probably at times fought with my younger sister, whom I'm now very close with, and that's kind of maybe a snapshot of myself, age 7. So.
Yeah, well, you know, a lot of interesting things there, Eric, but I could hear the perhaps future lawyer in you protesting to the teacher, right, on behalf of the other students and the unfair policies that
Right.
they were making. So I think that is what we're going to get into today. But tell us about some highlights or pivotal moments in your career before you started your own firm.
Yeah, sure thing, Portia. Happy to address that as well. Let's see. Good question to think about here, right? I would say in terms of pivotal highlights, I started my firm pretty young, pretty relatively quickly out of law school. So I graduated from law school in May of 98, took the New York State bar exam, passed it, got admitted in the state court, federal court, appellate courts, etc. And I worked at two small law firms out of law school. So between the fall of 98 and I'd say the early winter 2001. So I started my firm in 2001. So in terms of like pivotal, say career moments, I'd say before my practicing, I guess one would be working on a trial, assisting in, I would say, I think it was the winter, it was January and a 6-week trial, January and part of February, right, of 2000 at a law firm on an employment law, business law matter in state Supreme Court. I remember everything, just taking all the notes and helping to write some of the questions. And I was just like riveted. I thought it was fantastic. And then I remember also, right, pivotal moments of being intricately involved in some big settlements, but also getting a sense that law is both a practice and a business, which at first I resisted. I hated the idea of this being a business. It was all about justice and helping the client and being a zealous advocate. And what I learned over the years is that, especially if I want to thrive as my own practice, in order to do that, there needs to be a business component. And so I think another pivoting turning point for me was being at a small firm in 2000, 2001, where they required different marketing and development, business development techniques. And I would do those and I started to like them. So when I started my own practice, it was enjoyable to network, to market, to promote.
Yeah. And it's amazing, Eric, that you got that experience, with a trial before the state Supreme Court so early in your career. I'm sure that was really exciting. So, why did you decide to focus on employment law specifically when you started your own firm?
It's a great question. When I was in law school, I considered civil rights law, which I did practice some of in my earlier career. I liked employment law because it was not so cut and dry. It wasn't along the lines of tax law, property law. And there were a lot of shades of gray and a lot of room for argument. And I also enjoyed the human drama aspect of employment law. You had two sides that originally start out amicably, right? They go into the situation, especially in employment litigation, feeling optimistic. And somewhere along the lines, things go awry. So I enjoyed litigation because it gets a chance to help the party that's been aggrieved. But also, I like that there's a proactive element to it. I like the fact that there are all these laws that come out that are open to interpretation, and how we apply those laws in situations and how we draft policies for business owners, let's say, could be the difference between them being sued and facing fines and penalties, or potentially having situations where they won't get sued, or where if they have a Department of Labor inquiry into their business, they might come off with a clean record and say that was actually pretty painless. So that's, I think, why I chose employment law. It was a good human drama aspect. There's room for creative arguments, and I love dealing in shades of gray as opposed to more dry black and white like taxes or numbers and such.
Yeah. So, we discussed employment agreements on the podcast back during episode 41. And
Mhm.
non-compete clauses or agreements are often included as part of a larger employment agreement. Before we dig into non-competes, in your opinion, what are some other important sections of employment agreements?
I would say other sections of employment agreements that are important. And when you say important, are you referring to from the business owner's perspective, the employer, or from the employee's perspective of what to look for?
I would say both.
Or both? Or both, right? Yeah, sure, why
Uh-huh.
not? Why don't we start with the employer side first? I do represent a handful of employees in matters, but I'd say 80 to 85% of my work is for the small, mid-sized business owner, the tech company, the startup, the restaurant. So we'll start from the employer point of view. Other important aspects of an employment agreement, if you're the business owner, the employer, number one would be right confidentiality. Confidentiality clause in the agreement. And I say the agreement, I mean usually the employment agreement or some sort of NDA, non-disclosure agreement that basically forces a harsh word, that ensures that the employee complies with the keeping of certain, let's say, trade secrets, proprietary information, making sure they don't disclose that to a competitor, to the public. So you want to have like sound confidentiality clauses and provisions in an employment agreement. And number two, conflict of interest provisions. That, let's say, if an employee, for example, wants to try to work on the side hustle for one of your customers or clients, that might create a conflict of interest. And so you want to make sure you prohibit that. Like I've had clients where they didn't have those clauses and they did not have a non-compete, and yet one of their top managerial employees was working for an affiliate company that was a semi-customer, a huge conflict of interest. They were double dipping on their commissions, and there was little recourse. So I'd say number two is a good conflict of interest provision. And then maybe number three, because just to sake of time, maybe I'll give three examples, right? Would be and say and protection of, and I'd say number three would be a protection of proprietary information, right? Meaning that a client won't steal or take your trademarks, won't use your copyrighted materials and infringe upon those copyrights. So those are just some main clauses besides a non-compete, and maybe one more, if I may, a non-solicitation clause. Non-solicitation clauses are basically telling your employee, hey, while you work for me and for a period of time after you leave the employment, whether you're fired, resigned, or otherwise, you cannot poach or steal our clients. You can't poach or take our prospective clients, and you can't poach or steal our employees or undercut our vendors. So those are like the four big ones I'd say for from the employer's point of view.
Love it. Love it. So many professionals and executives struggle with understanding non-compete agreements. Can you explain what a non-compete agreement is?
I sure can. And I'd add quickly that with the employee side of the employment agreement, as and that's part of your question,
Mhm.
that you want to also have those clauses in place to make sure that they're reasonable in scope, that they're reasonable in terms of how long they govern for, like the non-solicitation, or how broadly they're drafted. You also want to make sure that your compensation is very clearly delineated in the employment agreement. So and to your question about the non-competes, could you repeat that one more time? Because I just
Yeah, yeah.
like to, yeah,
It was that many professionals and executives struggle with understanding non-compete agreements. So I just wanted you to explain what a non-compete agreement is for us.
sure. Yeah, that's a good starting point, right? Start from the basics. What is a non-compete agreement? So a non-compete agreement essentially is a part, usually a clause or provision in a contract. It's usually in an employment contract, but it could also be, let's say, if you are looking to bring on a business partner or to sell your business. And what it says is that let's say for employees, take that context, it says that the employee cannot essentially go and work for the competition either while they're working for your company or after you terminate them or after they resign. It basically defines what's considered the competition, right? And who's a competitor and what are considered competitive activities. And then it has a scope and duration of how long you can't work. Usually it's 6 months to a year. So and then usually have the geographic location elements as well. So basically non-compete what it means is you basically can't go, let's say if you are top level, marketing executive at a tech company and you have access to all the customer lists and the marketing campaigns and pricing, and you know which customers, are right for your services. And then you work for tech company A, let's say, you can't just go over to tech company B if you quit or you laid off and say, hey, I'm going to take with me, I've got all these great customer lists and sources and information, and let's use that to compete with and undercut company A. So it's saying, no, you can't do that for at least a period of time, 6 months, 9 months. I've seen them go as much as a year. And that way it gives the company a chance to have fair competition so that you're not undercutting them. And that's kind of what it basically says.
Right. So are there any major differences between a non-compete clause or agreement and other types of agreements?
I would say so, yes. Great question. Couple of differences. One is that in a lot of employment agreements, the clauses they end. The obligations from the employer and the employee, they stop when the employment stops. So, for example, you are promised a certain amount of pay, commissions, compensation. Usually, when the employment ends, that compensation or commission stops and it's cut off. And likewise, you as the employment have certain obligations to your employer, also that cease when the employment ends. But a non-compete provision one difference is that it's called a restrictive covenant and it survives the contract. So that means that, let's say your employer says, hey, listen, Portia, it's been great working with you, right? It's time to part ways. Or let's say you say to them, hey, listen, I think I want to part ways and move on. That's all well and good, but the confidentiality provision, the non-solicitation, and the non-compete are known as restrictive covenants, and they survive the contract. It's one way in which they're different. Another way in which they're different is that they can be enforced against a third party. So, in typical employment agreements, employment contracts, when let's say the employee breaches, the employer might be able to go after that employee. Or if the employer breaches, doesn't pay what's promised, or stiffs them on commissions, the employee can sue. But with a non-compete, if it's in existence, let's say someone works for Verizon and they want to go work for Sprint, something like that, Verizon can actually enforce the non-compete against Sprint. They can say, hey, listen, we've got a non-compete with Eric Sarver, our top chief technology officer, and he signed it, and we signed it. And if you take him on, knowing he's in violation, we can come after you under certain business law torts, causes of action. So those are a couple of ways in which a non-compete provision in an employment agreement or in a contract are different than other types of employment agreements and other types of provisions.
Yes, yes. And I've actually heard of that happening. Prior to starting this business, I was in consultative sales. And you know
Hmm.
that companies try to poach salespeople all the time to get a book of business and everything like that. So I actually heard of
Oh,
some
yes.
of that, Eric. So
Yeah.
in the US, non-compete agreements have been in the news for the last few years. I know that things can be different at the federal level and at the state levels, but what are some current trends that you've seen when it comes to restriction and full use of non-compete agreements? The Career 101 podcast is brought to you by Fly High Coaching, where we help our clients soar to their full potential. Entrepreneurs are setting out to achieve their business goals, but without the right support, it can be difficult, if not impossible. If you need business coaching, we're here to help. Check us out on our website, fly-highcoaching.com.
Sure, that's a great question, Portia. And you're right. Non-compete agreements have been in the news so often. When I post on LinkedIn about non-competes, whether it's an article or a podcast I talked about the issue on, I see so many comments and reshares because it's such a key issue. And I see comments 6 months later. So in the news, right, we over the last few years, we've been seeing the beating drum, the drum beat sort of marching towards banning and or limiting non-compete agreements, the use of non-competes, right? So what we've seen on the state legislature level, a number of states that have banned non-competes. For example, California, right, bans it even retroactively in many cases. And states like Minnesota. It's funny when you see North Dakota, Oklahoma, and California all in the same sentence, right? In terms of they all ban non-competes because they're so different politically. But we're seeing states that are banning non-competes. We're also seeing states that are doing partial bans, having like a minimum salary threshold, like to say, hey, listen, if someone's making $200,000 a year or more in an executive position, then it's okay to have a non-compete agreement. But if they're making 75,000 in lower level management, you can. And some of that has the rationale of that a non-compete should not be economically unduly burdensome, right, to a person's livelihood and their career, and it shouldn't cause economic duress. And so I think the understanding is if you're making $250,000 a year plus 100 grand in bonuses, you might be, let's say, after a few years, you might have enough of a nest egg in savings that you get a big severance payout, and maybe you can ride out the non-compete more than somebody who maybe makes 60,000 a year. And also you might be more privy and more prone to top secret confidential information. So the state legislature we're seeing move towards move towards banning and limiting non-competes. In the regulatory agency, we're seeing on that front and that plane a lot of agencies like the Federal Trade Commission, the FTC, it's what's known as, seeking to ban non-competes. And they actually finally got a ban in place, arguing that non-competes create unfair restrictions on competition for workers. And they say they're unfair in other ways and they, interfere with the natural flow of business and commerce. So they started to enforce a non-compete ban. Then another business group, other groups filed a federal case, an injunction against that non-compete, and the court stayed the non-competes. But now, under the new administration, the federal administration, we're predicting that the FTC will pull back on seeking that ban. Likewise, the National Labor Relations Board has been in the news in the last 2 years for under the Biden administration, right, for writing opinion letters basically saying that they believe non-competes violate the National Labor Relations Act, which was a bit of a stretch. Basically, what they said is that, right, let's say an employee wants to unionize or protest unfair working conditions. If that employee knows that they'll never be able to leave because they're locked in from a strict non-compete, they might be chilled, deterred in their speech that's in favor of workers' rights. So that was it. But that agency also is under new management, new people stepping in, and under the Trump administration, we might see them pull back. And the last but not least, the courts have been consistently striking down non-competes for being too long in duration and maybe too broad in scope. So we are seeing it's an interesting balancing where the federal level regulatory agencies are pulling back now into the administration, but the state legislatures are picking up the slack and trying to partially ban non-competes, including New York State, which is coming back with a second ban after the first bill was rejected.
Wow. Wow.
A lot, right? A lot to
Yeah.
digest and take in. Maybe we can
Yeah. No, no. I mean, it's great. I'm
mhm,
really interested in this topic, and we have a lot of our clients on
mhm,
the individual side and on the organizational side that are interested in non-competes for the reasons that you mentioned earlier, protecting confidential
mhm.
information, proprietary information, those sorts of things.
Yes.
You started telling us some of your predictions in terms of, with the new administration, the FTC might do some pullbacks for certain things, but where do you predict the courts will land on allowing or banning non-competes in the next 5 years?
I think the courts, Portia, will follow the legislature in their respective states. I think that most non-competes, not all, but most of them wind up in state court because the state court issue has to breach a contract. So I think, and other issues that are related to the state, and often the workers well, actually, it's interesting. Often the workers work in that state, but now with the advent of remote work, you might have employees in other states from the company, and you might have what's called diversity jurisdiction. So federal courts might look at these as well. But what I think is that the courts are going to look towards the state legislature, wherever the case may be located. And I think if the states that they're in are moving towards restriction, the courts will follow. And I think also that in some situations, even when the states are not moving towards restriction or more so than usual, I think courts are starting to look at non-competes as being an unfair burden on employees. And I think they're going to either strike them down or remand them to the company, for lack of a better term. Basically, says they might say to the company, hey, we might not strike down the whole non-compete, but we're going to ask you to limit the scope from 18 months to 6 months. Or, hey, this person's a traveling salesperson for your company. And so you can't ban them from competing in the whole Eastern Seaboard. So let's keep it more restricted. I do think, though, the geographic restrictions are going to be less of an issue because we're becoming much more of a remote workforce and a much more of a virtual society where people's sales territory, for example, they can make their sales or presentations and pitches on Zoom or Teams and share contracts through Google Dropbox. So I think you might find, I see many non-competes these days where it covers like North America and they're upheld because it's an e-commerce type position or an online company. But I do see the courts moving towards, at the very least, restricting and having companies pull back on some of the draconian non-competes.
Mhm. Great, great information. So, what do you think is important for executives or professionals to know when they're reviewing their non-compete clauses or agreements for the company that they work for?
That's a great question because it's taken all this sort of academic, this intellectual, this information and kind of like practical approach, right? How does it apply to the executive, the employee, or the employer? So answering your question, beginning with the executive, I think, right, they need to look at how strict is the non-compete? How much of how overly broad is it? So if they're coming in, let's say in sales, where as you know, that's the very common area, or they're coming, let's say, as an inventor, as an engineer in a tech company, I would look to the non-compete and say, how broadly is this written? If I'm in sales and I'm a truck salesperson, does this non-compete saying I can't work in sales when I leave this company? Because sales is pretty darn broad, right? That could be, I mean, well, I can't sell, other services or products, or if I'm in tech sales, why shouldn't I be able to sell real estate or, cars, right? So I think when I make sure it's not too broadly written, number one. Number two, if you're an executive, and you're negotiating a non-compete, I think you want to make sure that you have a clause in there that basically says that if you have a right to petition the company for like a carve-out exemption, basically to say, hey, if I get a new job offer, I will notify you and I'll ask you to review and in good faith review the job offer and in good faith consider A, if the non-compete applies, and B, if it does, carve out exception if having this non-compete would unduly burden me. And those, I think, are some key provisions. And number three is to make sure that it's not too long in duration. And if it is, you might want to negotiate for pay during that period. Say, listen, if you want to tie me up for a year after I leave this company, I might not get a job for a year, right? Because I might not be able to work for the competition. So in that case, I want you to pay me, whether it's payout on paid garden leave for a year post termination or sort of post termination, you pay out the garden leave and then the employment ends, or just pay me a tail severance that lasts for the time of the non-compete. Those are the factors to consider if you're the executive slash employee facing a non-compete clause.
Mhm.
If you're the
Great.
company, there are different factors.
Okay. Yeah. So that's exactly where I was going to go, Eric. So, from the company side or the employer side, as some people say, what are some important things that they should be thinking about when it comes to improving their non-compete clauses or agreements?
Well, I think first and foremost, the company, like my clients, for example, when they're drafting their employment agreements or non-competes, they need to look at where is the employee located? Where are they working from? Where do they live? What state are they in? Because if the company has a remote employee in California and they're running a non-compete, not only is a non-compete null and void under California state law, but the employee might have a grounds for a cause of action if the company tries to enforce it. So I think the first step is when you're writing your employment agreements with your new employees or your existing employees, look at what state they're in. Number two, I think they need to look at, right, how long they want to restrict their workers for. And that period of time might change. If they really think an employee is top level C-suite, chief marketing officer who knows all the secret sauce of all the marketing and all the customer lists and client lists, they may need to consider giving them payment of enhanced severance during the non-compete period. And number three, right, they want to look at, right, say, when do they bring up the non-compete? Is it in the employment agreement? Is it, let's say, if they're offering the employee restricted stock down the road, or when they give them severance? So I think you want to be mindful of that and not make the scope too broad and too long. Because if you put in, I recently saw for a client, I'm negotiating for the employee, and his non-compete is 2 years. And I find that just to be not enforceable. I've never seen a court, not never, maybe like 25 years ago, I saw a couple of courts enforce that, but they're shrinking the period to 9 months, 6 months, maybe 12 months tops.
Hmm. Yeah, I've seen some 2-year non-competes. It was, a
Mm,
while ago though.
yeah.
So, to stick with the employer side or the company, if non-compete clauses or agreements are banned, what are some other steps that companies can take to protect their trade secrets or proprietary information if, we'll say, an executive leaves to go work for the competition?
I see this a lot, and it comes out in terms of clients approaching me with this dilemma, and I tell them it's all about how well you draft the employment agreement and the offer letter and your employee handbooks for that matter. And so I, for example, right, would draft an employment agreement that said that it has very strict protection. I would draft an employment agreement with very strict protections for proprietary information, right? Trademarks, secrets, and I would expand the definition of that proprietary information, basically to say that an ex-employee, when they become an ex-employee, cannot use the company's customer lists, their client list, their sales techniques, their marketing campaigns, that they can also coach their prospective employees. So I would make sure that your clauses against proprietary information being appropriated, or your confidentiality clauses and your non-solicitation clauses are very robust, right? Very beefed up. So I think that if you have those clauses in place and one of your chief executives tries to leave the competition, you can say, hey, I have reason to be concerned that you are going to misappropriate, misuse this proprietary information or the confidential information. And so you might have grounds to stop them from doing that. And in the process, it's like a de facto non-compete, right? It keeps them from, because if they can't bring that to the competition might say, well, then I don't really want to hire you, right? So that's how, from a company point of view, I protect the company's trade secrets, confidential information from being misused and gaining an unfair competitive advantage.
Mhm. So, Eric, tell us more about
Mhm.
your firm.
Okay, sure. Yes, right. So my firm, our law firm, PLC, formerly known as Lofts Eric Sarver, I started in April 2001. And in the beginning, I'd say from 2001 to 2012, 2013, I represented exclusively employees, believe it or not. I was an employee side, employment litigation, civil rights, and appeals firm. I worked on civil rights litigation, in education law, in employment law, in free speech. And I also worked on immigration law and appeals. I say that because I think it gives me a window of insight into how the employee's attorney works and thinks when I take on a case for an employer. Because over the last, I'd say, 12, 13 years, 12 years, I started to shift my practice. So now my practice works with small to mid-sized business owners. So our clientele include business owners. They could be a new entrepreneur, tech company, startup. It could be a fourth generation family-owned insurance business, restaurant, hotel, car wash, dry cleaner, etc. But what we do is on the employment law side, we defend companies from lawsuits from ex-employees or current employees, whether that's for wage and hour, overtime issues, or allegations of discrimination. We often try to litigate and find solutions. We try to negotiate, we try to mediate, but I do defend companies. Also, we defend companies from New York State or New Jersey Department of Labor audits, investigations, and inquiries. So a lot of times the New York State Department of Labor will come after a company and they'll say, hey, you misclassified your workers. You have all these independent contractors and freelance workers, and they should have been employees. So we defend in those audits. And then we also do compliance. We help companies to follow, you have all these federal and state laws. We talked about non-compete. So what about salary transparency and wage and hour issues and notification of sick leave rights, FMLA? We help companies, let's get you on track, help you follow the law, understand what you have to do, and keep you out of trouble so you don't get sued. And then last but not least, we draft employee handbooks and employment contracts, non-compete agreements, right? We help companies to revise those, revamp those. And then lastly, that's all the employment law side.
Mhm.
And on the business law side, which is about 40% of our practice, we do business formation, restructuring of a corporation or company, buy-sell agreements for companies, a buying company, selling company. We do commercial litigation. That means, a company is suing another business for breach of contract or an account stated, or maybe that company is suing their clients, right? Or poaching their workers in a non-compete violation, right? So a lot of business law and employment law, compliance, litigation, drafting employee handbooks, things like that. And I'd say in terms of we're mainly in New York, New Jersey. That's where I'm licensed and admitted. We do federal court, state court, do appeals. And then we also do some internal investigations for companies. So we're pretty much industry agnostic. I say we have several of counsel associates that work with me, whom I supervise. but everything goes through me. I'm the final, the buck stops here. I'm the main outwardly facing. Clients can expect to speak with me regularly on all their issues and questions. And we have a small team of marketing consultant, CPA, bookkeeper, website developer, assistant, so that our customers and our clients are fairly represented. They know we have the resources to meet their needs.
Yeah, that's great. We'll be providing a link to your website and other social channels in our show notes so people can find you online. But now, Eric, I
Sure,
want to ask you our final question that we ask all of our guests. How do
sure.
you think executives or professionals can get a positive edge in their career?
Well, it's a great question. And I'd add that executives and professionals, by the way, if they're negotiating employment contracts or commission agreements, we do those as well. But one way to get an edge, I think, is to learn some new skill sets. This is me taking off my employment lawyer hat and just focus on the employment landscape. I think that there's a growing need for people with a knowledge of technology, including artificial intelligence. So executives who learn that skill set can be really benefited when they're searching in their career. Number two, I think, is the importance of networking, being out there, doing what you and I are doing right now, for example, having conversations with people, guesting on podcasts, maybe starting your own podcast, but being three-dimensional, more than just a name and your history of your work on a 1 to 2 page resume. I think that companies are looking for more well-rounded, well-versed, well-informed people. And if I had to do it over again, when I applied for law firms back in the late 90s and 2000, it was a different time, right? I don't know if you remember this, I might be aging myself here, but we would fax the resume, you
Yeah.
type it in, you get the crunching sound that maybe is not known to our younger audience members listening
Mhm.
today. You'd get them in the mail, right? So, but I think that with the advent of technology and online recruiting, a lot of companies might get 500 resumes in a day. So you want to make sure that you are out there on LinkedIn and video marketing. And that's how I think executives, whether it's to advance their career or to start their own business or to get a job somewhere, need to be out and about and visible.
I definitely agree, Eric. We have clients
Mm.
that are baby boomers or sometimes Gen Xers, and they've told
Mhm.
me before, yeah, Portia, the last time I looked for a job, it was in the classified section of the newspaper. So,
Mm.
we've definitely helped clients in those ways. And I do remember fax machines. There was a
Mm.
big thing a couple of years ago where they were saying a lot of
Mm.
Gen Z employees did not know what a fax machine was. So, yeah. But Eric, you have shared a lot of wisdom with us today, and I'm sure that our listeners could use it to be more confident in their careers and when reviewing their agreements. We appreciate you being with us.
Portia, thank you so much for having me. And I'll say that I hope the listeners also realize that another part of their job search might be using coaching, like you're like fire coaching to help them with their resumes, their presentation skills. So I wanted to just kind of mention, I make sure I end that as well. And thank you very much for having me. It's been a pleasure being on your show. I really appreciated the opportunity to discuss topics that I feel passionately about. I hope I can help your listeners with their employment law and business law needs. So thank you.
This episode was brought to you by the Bravebird Career Alliance, the go-to membership designed for seasoned executives and ambitious professionals with everything you need for career planning, strategy, training, and support. Thank you again for listening to the Career 101 podcast. I hope you have at least one key takeaway that you can use in your own career. If you enjoyed hanging out with us, please rate, subscribe, and share this podcast. Until next time, here's to your success.